Hi folks, so today I'm going to talk about this new Supreme Court case, or relatively new. It's called Kidd versus the Industrial Commission, and it deals with this individual applying for PTD, so permanent total disability compensation. So the facts are such that this individual Kidd was injured back in 2013, so she injured her back. She ended up returning to work in 2014. In 2015, she underwent spinal surgery. She took part in vocational rehabilitation. And then in 2017, she ended up finding a job working as a cafeteria server. Did that for about 8 months. And due to back pain and leg pain, she had to stop, so she quit. So then she subsequently files for permanent total disability at the Industrial Commission. It's denied. She files, or her attorney files, what's called mandamus to the 10th District. 10th District grants, or they overturn the decision of the Industrial Commission and grant the PTD, but then the employer appeals, or the IC appeals, and then the Supreme Court overturned the decision of the 10th District and ultimately denied her permanent total disability. So, and some of the facts surrounding the application of permanent total disability was there was a dispute about what her abilities were. So her doctor was saying, hey, she's only capable of doing this sedentary work, and but actually she's not able to really even do sedentary work because she needs breaks all the time. The IC had a doctor, and they said, well, she'd be capable of sedentary work, and she would be able to do breaks. And so we have to, and that would be okay. So we have to look at some definitions. So generally speaking, permanent total is kind of defined in Ohio Revised Code 4123-58C2, and it says PTD is appropriate when the impairment resulting from the employee's injury prevents the employee from engaging in sustained remunerative employment, utilizing the skills the employee has or may reasonably expect to develop. So if the employee, if they can do this or that, and even with this or that skill, he or she's not able to find a job, then she would be found permanently totally disabled. And then they define PTD also in the Ohio Administrative Code under 4121-3-34B1. PTD means the inability to perform sustained and remunerative employment due to the allowed conditions in the claim. So again, if somebody has physical or psychological conditions that is preventing them from performing sustained remunerative employment, then they should, or at least that's the idea, they should be entitled to receive permanent total disability. So one thing that's important to note is that doesn't mean that, well, I used to be, a welder and I can't weld anymore, so I'm PTD. No, that's not what it means. It means that you can't do any sustained remunerative employment. So you might have been a welder, or you might have been, over-the-road truck driver, and your work injury may prevent you from doing that specific type of job, but that doesn't mean you're PTD. That just means you can't do that type of job. So it's sustained remunerative employment from, kind of all work. And in relation to that, Ohio BWC has something called vocational rehabilitation, where you can learn, where they'll pay you what's called living maintenance while you learn a new skill in order to possibly transition to another type of career. So anyway, so that's the definition of PTD. And then the law further goes on to state that the work the employee may be able to perform need not be regular or even daily. It may be intermittent and occasional. It may be part-time. So if you could do part-time work, then you're not entitled to permanent total disability, which doesn't necessarily seem fair to me, but that's the law in Ohio. So if you're capable of doing some kind of part-time work, then the Ohio BWC says you should not be entitled to permanent total disability. So and because sedentary work is part of this specific case, the Ohio Administrative Code, again, defines, and it's under 4121-3-34B2, defines sedentary work in the following way. It involves sitting most of the time, but may involve standing for brief periods of times, and also may be required to lift up to 10 pounds occasionally. So if If your doctor says you can't do kind of standing work, but you can do sedentary work, that is the definition of sedentary work in the Ohio Administrative Code. So I guess if you can't stand at all, then you wouldn't be capable of sedentary work, or you can't walk at all, then you wouldn't be capable of sedentary work. So that wouldn't apply to you. But that's in this particular case, the Ohio Supreme Court found that this lady, despite the fact that she needed to take, I guess, breaks every 15 minutes, she still was capable of sedentary work. And the other controversial thing in this case is the Industrial Commission basically had said, hey, there's these things in the workplace. They have sit-stand desks and these types of things, and because they have sit-stand desks, this person should be able to use like those things and working from home and whatnot. And because of that, that gives folks even more latitude to be able to work. And because of that, all the more reason this person isn't permanently and totally disabled. So getting back to kind of the definitions or some of the ideas in PTD, if a claimant's not found medically PTD, then they'll look at what's called the Stevenson factors. So if your doctor says, hey, this person is not capable of work at all, i.e., in this case, that wasn't the situation, because I think her doctor said that she was not, and then the commission's doctor said that she was sedentary. And because there was a dispute, and then they looked at the Stevenson factors. So if both doctors said that this person was medically PTD, then it would kind of be the end of the story. But that wasn't the case here. So then they look at the Stevenson factors. And so even if they're not found medically PTD, they still might receive permanent total disability based upon the analysis of the Stevenson factors. And basically the Stevenson factors are things like age, education, job experience, and ability to learn, their language, etc. So for example, if you're like 90 years old, that would be kind of a detriment to returning to the workforce, or you had the educational level of, elementary school and you're illiterate, then that would tend to suggest that you're not capable of working, or it'd be harder for you to get work. They look at those things, they kind of balance those. But so, and again, in KID, the issue was the Supreme Court says, hey, she is capable of sedentary work, despite the fact that she had to take breaks every 15 minutes. And also, again, there's these things like sit-stand desks and work from home. So that was a decision of the Supreme Court. They denied PTD. But the dissent brought up some relevant points, and frankly, I think the dissent in this case kind of had a more realistic view of how the world works, or how reality works. And the dissent said, like, no one is going to hire this individual if she has to take breaks every 15 minutes. It's just not going to happen. And the other fact of the matter is just, she mentions that the Supreme Court and the Industrial Commission mentioned things like sit-stand desks and works from home arrangements. But the dissent basically said, hey, employers are pushing back from work from home. And that's true to a certain extent. Work from home, I think there's still a lot of work from home, but they're kind of pushing back. And the reality is an employer going to take a chance on somebody who, like this lady, had just a high school education, was 58 years old, had no experience working in kind of office arrangement. And the reality is, it's very, and also, are they going to provide this individual like a sit-stand desk? And I don't know, if you looked at the price of those sit-stand desks, those things aren't cheap. They're, I've seen them go from $700 to $1,000 if you want to get the powered ones, anyways. But so the reality is, and I think the dissent is kind of right, this lady's not going to be able to find a job that takes into account all of her limitations. So, but that's the decision of this KID case, and the controversy in the KID case really revolved around this sedentary, whether or not her physical abilities fell within the scope of the definition of sedentary. as laid out by the Ohio Administrative Code. And there's a prior case that deals with this in more detail called LIPCAP, which was kind of discussed in this case. But so that's what this case says. And again, it's this idea that the Industrial Commission can consider workplace accommodations, different kind of adaptive workplace furniture that can be given to employees. So point being is permanent total disability is not a walk in the park to get it. You know, people apply for it, they get it, you know, because it happens. We pursue permanent total disability on our clients and they get permanently total disability, but then but it's denied as well. So, and it's kind of, I don't know, this lady, I think my take on that is she put in the good fight. She had this back injury. She tried to work as this college cafeteria server. She couldn't do it because of the pain in her back and lower legs. And then naturally she can't work, so she files for PTD. I'm assuming that this lady also filed for Social Security disability. Social Security disability uses different standards, rules, and also Social Security disability is a federal thing. PTD, that's an Ohio thing. They use different kind of definitions. They use different requirements as to when you can receive one versus the other. In some ways, to pursue Social Security disability, it's a lower bar. In some instances, you could pursue, and in fact, there are some situations where somebody may actually be on Social Security disability or have been found disabled under the Social Security disability scheme, but they filed for permanent total disability because you could do that, and it's denied. So, yeah. Anyways, so that's the KID case. I will put the citation to the case. You can read it if you want. And I don't know. As I say at the end of all these videos, though, workers' comp is a complicated beast. I would not recommend you do this on your own. Ask your friends, your neighbor, your doctor for who they recommend, and then get a workers' comp attorney involved with your situation. So this has been Kip from Malik. Thanks for listening to this video. As you can see, it's finally springtime, and it's warm again in Ohio. So, all right, thank you. Bye.